everyone. Welcome back to Analog IAS Current Affair Analysis for 18th February 2021. In yesterday's video, we have discussed about how India should slowly move towards a carbon neutral economy or a post carbon economy where there are no carbon emissions at all. Now, in the first topic that we'll be discussing today, we'll be looking at how the National Hydrogen Mission, which is envisaged to be a mission that is taking India towards a cleaner fuel, will achieve this objective. And in the second part of the discussion, we'll be looking at the Kane arbitration case. In our GS2 syllabus, alternative disputes mechanism is one issue which has always been a point of contention in Indian judiciary. So let us use this example of Kane arbitration case and how we can do better in our arbitration cases. In yesterday's discussion with respect to carbon capture, we were discussing how transport sector is one of the major reason as to why emissions have been increasing over the past few years. In that context, we have noticed that transport sector contributes to around 17% of our carbon emissions. So this is one of the fastest sectors that can undergo a transformational shift provided we have the right kind of fuels. Even from an economic perspective, if you take a look at our current account, it is always under deficit. The current account deficit, as we know today, except during the pandemic, India has always faced this issue of current account deficit. The major reason is fuel. India does not have a fuel resource, so it always depended on external resources to have this petrol and diesel to keep our economy running. But if we have to change the situation, eventually we will have to move away from these fossil fuels and also reduce the carbon emissions if we really want to achieve the objective of post carbon economy. And this trend of energy transition is underway at an exceptional level, and several countries are betting big on hydrogen. Hydrogen is said to emerge as the top clean fuel with its high energy density and versatility. Now, what do you mean by this? For a unit of this fuel, it produces more energy. That is the reason it is called an energy dense fuel. So, Government of India's National Hydrogen Energy Mission, it is an initiative that will capitalize on one of the most abundant elements on earth for cleaner alternative fuel. Yes, hydrogen is one of the most cleanest fuel options available out there in abundance. But here we have to understand the practical challenge. We have to understand the importance of green hydrogen. So it is not the production of hydrogen which is the challenge, but the production of green hydrogen. The usage of hydrogen will not only help us in achieving our emissions, but also reduce the import dependency on fossil fuels. Now, what is this green hydrogen? So, hydrogen production is classified into different kinds: grey, blue, and green. Green production of hydrogen is the one where there is absolutely no carbon emission. And in this blue hydrogen production, there is a carbon offset technology which is inherent in it. Now, what do you mean by this carbon offset? Say if this hydrogen production unit produces some X units of carbon, it will have a technology which is inherent to this system which also absorbs this X units of carbon produced, making it a net zero carbon emission model. The next one is the grey hydrogen, wherein there is carbon emission involved. Apart from this, many private organizations are exploring technologies which can convert bio waste and plastic waste into hydrogen. So there is a huge scope for investment in this technology which can combat India's twin problem of one, waste management, and at the same time we'll be moving towards energy security as well, because remember we have talked about how high current account deficit is a problem for Indian economy. But how does it exactly function? For this you have to understand the concept of fuel cell. You have to understand that hydrogen by itself is not a source of fuel. It combines with oxygen and then produces the energy required for the vehicle to run. But for this process to take place, it needs an electricity, and the platform on which this electricity and the required processes are run is called a fuel cell. Now this fuel cell will be the moving force behind a vehicle, and it is quite different from a electric vehicle. Even though this is a form of a electric vehicle, it is very different when you compare it with a battery electric vehicle like that of Tesla. So if you take a look at the hydrogen model e-vehicle, this is the kind of vehicle that you will find across several countries in Asia Pacific. Like say for example Japan, South Korea, all these countries have been encouraging hydrogen based fuel cells. In 2017, Japan formulated the basic hydrogen strategy which sets out the country's action plan till 2030, and establishment of an international supply chain has been one of its priority. Why is Japan betting big on this hydrogen vehicle? Because in comparison with the battery electric vehicle of Tesla, it needs a supercharger, and even if you charge it for 45 minutes, in the present state of things it can never compete with that of a hydrogen vehicle, because the refueling time is just 5 minutes, and in this 5 minutes it can go much farther than the normal e-vehicles of those that run by battery. So this battery charging infrastructure is much more expensive than this hydrogen. But when you ask the proponents of this battery vehicle, like Elon Musk, the CEO of Tesla, he called this a very stupid concept. The one that is run by hydrogen is a very stupid concept according to Elon Musk, because it is not efficient. It is not safe according to him. But South Korean scientists and Japanese car makers very much assert that it is safe, because one of the safety concerns that was raised by a lot of opponents of this hydrogen fuel cells is hydrogen, when stored at pressurized low temperatures, there is a possibility of an explosion. Now, similarly, this is the case with even compressed natural gas as well, or even our LPG cylinders. If they are safe, why not the normal hydrogen fuel cells? Is the question that these scientists raise. So, the only challenge and the only roadblock in the success of this hydrogen based fuel cells is that we don't have proper refueling stations. Similarly, we don't have enough number of charging stations, and at the same time there should be safety control of the usage of hydrogen in our country. So this requires a proper legislation from our side and transparency in nation's hydrogen pricing system as well. So we have to learn from what South Korea has done in this respect, because it created a legislation which promoted the safe control of hydrogen production, and hydrogen vehicles, charging stations, and fuel cells, all of them will be registered on a national level database to maintain transparency. Because unlike petroleum, hydrogen is very easy to produce, and there is a possibility that instead of using the green hydrogen, the gray variety of hydrogen, which is much more easier to produce, can be adulterated with, and it can increase the pollution again. So it would defy the purposes. So it requires strict regulation from our end. So these are the problems associated. One is that of scale, and the second one is with respect to need of a proper legislation and a ecosystem that promotes this manufacturing. This is how we can move towards Atmanirbharta as far as our transport sector is considered. The second article is about the Kane arbitration case that we're talking about in the context of the retrospective taxation. Let me give a brief background about this issue. Around 2006 and 2007, Kane UK has transferred shares of Kane India holdings to Kane India. So the income tax authorities felt that Kane UK, which happens to be the parent organization, In this transaction of transferring shares from the Kane India Holdings, which is an organization one, to its sister affiliate called Kane India, which is the second organization in this case, has made some sort of capital gains. Now, income tax authorities have felt that this capital gains that Keynes UK has accrued to its account should be made accountable under the IT Act, and they have slapped a 24,500 crores income tax on this company. But there are different interpretations of the capital gains, and the company outrightly refused to pay the tax, which prompted cases being filed at the Income Tax Appellate Tribunal and also the Delhi High Court. So, at that particular point of time, there was no tax law which spoke about how to deal with this kind of companies which are considered to be subsidiaries of a parent company. In order to address this anomaly, what happened was in 2012, the Indian government, during its budget proposal, has amended the tax code retrospectively, giving itself the power to go after mergers and acquisitions all the way back to 1962. So, this was a case of retrospective taxation. That is the reason, whenever we talk about the Kane taxation case, the issue of retrospective taxation comes into the picture. In 2015, the Kane Energy has commenced an international arbitration proceedings against the Indian government. Now, what do you mean by arbitration? Whenever there is a dispute, especially in the case of a contract, both the cases will file a case at a neutral third party. So, in this case, this international arbitration was filed by Kane Energy. Where did they file this case? In PCA, or Permanent Court of Arbitration. Just a brief background for prelims. This Permanent Court of Arbitration was established way back in 1899. That is even before the formation of League of Nations. It is headquartered at Hague, and it is in Netherlands. And the purpose is to have an intergovernmental organization which is dedicated to serve the international community, especially with this aspect of dispute resolution, and also to facilitate this arbitration and other forms of dispute resolution between states has been another objective or mandate of this PCA. India, before this judgment came out, where PCA has declared that Indian government was wrong in applying a retrospective tax on this energy giant, that is Kane Energy Limited, has lost another case which is similar against Vodafone. Even in this case, the Permanent Court of Arbitration has ruled that India has failed to fulfill its obligations under the UK India Bilateral Investment Treaty, that is BIT, and international laws which seek payments from the company for its business or reorganization in the country. But what is India's stance in this case? The government will study the award, and it decided that all its aspects will be carefully answered after consultation with its council. So, after such consultations, the government will probably reconsider all the options and make a decision on the further course of action. So, here is what we have to understand. An investment friendly business environment would increase economic activity. It would help raise more revenue over time for the government. But issues like this retrospective taxation will always act as a roadblock for investments. So, it is always hoped that tax officials desire to deny their defeat or to try and hang on to legally untenable revenue systems will always be problematic whenever we are seeking investments from abroad. That is one of the reason why FDI is limited to a few sectors like technology and software. The takeaway from this entire debate is whether India will actually try to balance between the international laws versus domestic laws. This is simply not a matter of sovereignty of enforcing our own laws and the debate that it is against investor rights. It goes much beyond that. We have to be very reasonable in our uh, laws while framing those laws, and it should be acceptable to the international business community as well. Otherwise, it would be very difficult for us to attract this investments in our country. Now, going by the trends that are exhibited by the government, in 2012 itself, when Vodafone case was being heard by the Supreme Court, the court remarked that Indian government was wrong in slapping a fine on Vodafone, and therefore it also applies to Kane. However, despite the warning from the Supreme Court, the Indian government has went ahead to create this retrospective taxation law. And in 2016, if you take a look at the details of the model bilateral investment treaty that India has brought out, there was one particular clause which said that this treaty will definitely not apply to any tax laws. Now, this is a blanket ban, and it is a non starter for any negotiation with a country with respect to trade. Because if you take a look at various bilateral investment treaties across the world, this aspect of taxation will be very specific to the issue. As such, taxation is not a one point reference. There are various different issues within the ambit of tax laws. For example, there might be different take on double taxation avoidance agreements. Similarly, there can be a clause on retrospective taxation. So the underlying point that I'm trying to make here is India cannot have this sort of vague laws which kind of project ourselves to be a protectionist regime. We have to be fair and not look at the international companies in positive light as builders of our future, and we have to make them partners in our economic growth. In this context, what we have to realize is there is definitely a loophole in the law or a gap in the law, especially with the Arbitration and Conciliation Act of 1996. So there is a need to address this gap. This law does not actually address how to deal with international awards, so especially international arbitration awards. So this is the policy stance that the government must be very clear about, keeping in the needs of our country. India has national infrastructure pipeline and Atmanirbharta as its strong pillars for economic growth in the future. For this, FDI is one of the most important factor which determines its success. In order to have a stable policy, addressing this key loophole which has been a point of contention for a very long time in our arbitration debates is the way forward according to the article writer. So that is the gist of this article.